Estate of Keith M. Penn. Mr.
Sir, would
Dawson?
you want to swear them in?
Oh, yeah, thank you. Sorry,
You're
I'm
welcome.
kind of off kilter since it's a 1:30 instead of 10:30
Yes,
or 10
sir.
o'clock. Raise your right hand, please, if you're going to testify.
Do you solemnly swear affirm the testimony you're giving today is true and correct, so help you God?
I do.
Thank you.
All right, now you may proceed, Mr. Dawson.
Thank you, Judge. Would you state your name, please?
Teresa Renee Penn,
And how are you related to Keith Penn?
his wife.
Okay, and I'd like you to speak up so the court could hear you, okay?
Okay.
And he passed away on May 7, 2024, is that correct?
Yes,
And he was a resident, you're a resident of Chambers County, Texas, is that right?
yes,
And we have filed an application to probate a copy of the will, correct?
yes,
Is the copy of a will the true and correct representation of the original?
yes,
And have you made an exhaustive search for the will?
yes, I have.
Do you believe that the copy that we have offered is indeed a true and correct reflection of his desires with regard to the disposition of his property and assets?
Yes,
And that document is dated January 22nd, 2019. That is, the will's dated January 22nd, 2019, correct?
yes,
And a necessity exists for the administration,
yes,
and there was no children born or adopted after the date of the will, is that right?
correct.
Now, what are how many kids did he have?
3,
What are the first names of all the kids?
Brian, Curtis, and Dalton.
Are they aware of this proceeding?
Yes,
And they have consented and entered their appearance in this proceeding, is that correct?
yes,
And you were married in 1978 to Keith M. Penn, is that right?
yes,
Under his will that we're offering for probate, there's no gifts to any charitable organization or any governmental entity, is that right?
yes,
And it's a non-taxable estate, right?
yes,
And there's no necessity for an appraisal, is that correct, ma'am?
correct,
And he at no time applied for Medicaid benefits, is that right?
correct,
And he's named you as to serve as independent executor, that is Teresa R. Penn, and you're qualified and not disqualified from serving, is that right?
yes,
And a true and correct copy of the will we have filed, and we're asking the court to admit that as the original will of your husband, and that you be appointed independent executor, is that correct?
yes,
Judge, I'd ask you to take judicial notice of the copy of the will being offered as a will, and to appoint Teresa R. Penn as independent executor to serve without bond.
Thank you, Counselor. All right, cause number 85, the interest of Joan E. Fitzgerald, incapacitated person. Mr. Carlson,
Yes, Your Honor.
good morning. Good afternoon.
Is Mr. Mahoney on the call?
Mr. Mahoney, are you on? No, I don't see Mr. Mahoney.
Well, I know he signed off on the order, but I expected him to be present.
Yeah, will you mute yourself, see if you can get a hold of it? Do you have a number for him?
Yes, I'll call him right now.
Okay, we'll skip you and come back.
Thank you.
All right, cause number 19, the interest of Gillian Fisher. Ms. Poland.
Jillian.
Yes. Good afternoon, Your Honor.
Good
Thank
afternoon.
you. Thank you. Christina, will you please state your name for the court?
Christina Fisher.
And are you the mother of Jillian Fisher?
Yes.
Jillian is in the background there. Is that right?
Yep. She's excited. She can see y'all.
Oh, good. Hi, Jillian.
Hi, Gillian.
Is it true that Jillian's 20 years old?
Yes.
And you all are residents of Chambers County. Is that correct?
Correct.
And it- disability and Jillian's not able to execute a supported decision-making agreement. Is that correct?
Yeah, she's not at all.
Okay, I'm sorry. I'm getting a notice that my internet is unstable, so I apologize.
You cut out a little bit.
You did, but go ahead. You're frozen, Ms. Bowles.
I think it really cut out
Okay.
that time.
Yeah,
Am I back? Can't
You're
tell.
back.
we can hear you.
I'm back.
Yes, ma'am.
Okay, I apologize, Your Honor.
It's okay.
Okay, and the nature of Jillian's disability is total. Is that correct? She's not able to make decisions for herself or about where she's going to live or what kind of medical treatment she's going to get. Is that correct?
No, she's cognitively about a 1-year-old.
Okay, very good. And Jillian lives with you and her father, and you guys are her primary caregivers. Is that right?
Correct.
And you're qualified to be appointed as Jillian's as the guardian of Jillian's person. Is that correct?
Yes.
And Jillian doesn't have any bank accounts that are in her own name or assets that she has that are in her own name. Is that correct?
No, she does not.
Okay. And you and Jillian's father and Jillian's siblings have all signed
Cutting out again, Ms. Bowles.
person for Jillian. Is that right?
Would you ask that question again? You cut out, please.
Am I back? Sorry.
That's okay.
Okay, yes, I'm sorry, Your Honor. Christina,
Yes.
you and Gary and Jillian's siblings are all in agreement that you should be serving as guardian of the person for Jillian. Is that correct?
Correct.
And uh, all the questions I have, I pass the witness to Mr. Cotton.
It's got it.
Yes. Hi, Christina. It's Weston
Am I
Cotton.
back?
Hey.
And we met and you introduced me to Gillian. And we discussed the guardianship and some of the things that you were going to do. Nothing has changed materially in your household, has it?
No, sir.
Okay, so you feel like you're qualified and ready to serve as our guardian, as you have done for the last 20 years.
Correct.
Nothing further, Judge. I'd pass the witness.
Ms. Bowles.
Your Honor, I have no further witnesses to call and no further questions. We just ask that this court appoint Christina Fisher as guardian of the person for Jillian Fisher.
Ms. Cotton.
You might want to look at the doctor's letter, Judge, and introduce that into evidence.
Oh, yes. Thank you, Mr. Cotton. Yes, I would ask the court to enter the doctor's letter as evidence in this matter.
And no objection from Mr. Cotton, so
No objection, Judge.
it is entered into evidence for the record. What about a bond?
I think it should be
Your
a
Honor,
minimal
sorry.
bond, Judge. It's a good family, good home. They're taking good care of her. I think a minimum bond so there wouldn't be any more burden on them.
Okay. I'll do a $50 cash bond, and you've agreed to a fee of $700, correct?
Yes, Judge, and I have that in my file.
All right, hereby appoint the guardian of the person of Miss Gillian Fisher. Thank you all.
Thank you.
Thank you, Judge.
Thank you.
Now be
Thank you, Weston.
excused. You bet.
Maybe.
Good to see you, Bren.
Yeah.
All right, cause number, Mr. Carlson, did you get Mr. Matthew on?
I talked to his assistant, Your Honor, and unfortunately, he was not in the office and she was texting him to get online, but I have not heard back.
Okay, we'll come back to you.
Okay.
All right, cause number 46, the state of Aaron Keith Aguilar.
Hi, Your Honor.
Good morning.
I think I fell off
Afternoon.
if you swore in everybody, so I still need to be sworn.
You need to raise your right hand, please.
Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
Yes.
Thank
And
you.
you may proceed.
Judge Aaron Keith Aguilar died on January 1st, 2024 in Harris County, Texas at the age of 61. 4 years have not elapsed since the date of his death. The court has jurisdiction and venue over the estate in that decedent was domiciled, had a fixed place of residence in Chambers County at the time of his death. He died testate and his will was signed on September 12th, 2009. Citation's been served and returned in a manner and length of time required by the probate code. A necessity exists for the administration of the estate. To the best of my knowledge, the will filed for probate was never revoked by Aaron Keith Aguilar. And I do recognize the will that was filed for probate to be the true original of the will of Aaron Keith Aguilar. No state governmental agency or charitable organization is named by the will as a devisee. No child was born or adopted by decedent after the date of the will. No marriage was ever dissolved after the date this will was made. To the best of my knowledge, he did not apply for or receive Medicaid benefits after March 1, 2005. The will named Laureen M. Aguilar to serve as independent executor to act without bond or other security. All beneficiaries consent to an independent administration. And to the best of my knowledge, the proof required for probate's been made. Ms. Aguilar is not disqualified by law from accepting letters testamentary or from serving as executor and is entitled to such letters and is the person named in decedent's will. We ask that the court would admit the will to probate, waive appraisals, and appoint Ms. Aguilar as independent executor.
So done. Thank you, Counselor.
Thank you.
All right, cause number 48,
Yes, Your Honor.
state of Mark Kincaid. You may proceed, Counselor.
Right, Mark Kevin Kincaid died on September 29, 2023 in Chambers County at the age of 63, and 4 years have not elapsed since the date of his death. The court has jurisdiction and venue over this estate in that he was domiciled and had a fixed place of residence in Chambers County at the time of his death. Mr. Kincaid died with a will that was signed on September 22nd, 2017. Citation's been served and returned in a matter and length required by the probate code. A necessity exists for the administration of this estate. To the best of my knowledge, the will filed for probate was never revoked by Mark Kevin Kincaid and is the original will. No state government agency or charitable organization is named by the Mr. Kincaid as a devisee, and after the date of this will, no child was born or adopted by Mr. Kincaid. No marriage was dissolved after the will was made by divorce, annulment, or declaration the marriage was void. To the best of my knowledge, he did not apply for or receive Medicaid benefits on or after March 1, 2005, and the will named his wife, Sandra K. Kincaid, to serve as independent executrix to act without bond or other security. All beneficiaries consent to an independent administration, and to the best of my knowledge, the proof required for probate has been made. Ms. Kincaid is not disqualified by law from accepting letters testamentary or from serving as executrix, and is entitled to such letters and is the person named in decedent's will. We'd ask the court to admit the will to probate and appoint Sandra K. Kincaid as independent executrix to serve without bond and to waive appraisers.
Thank you, Counselor. We're done. Thank you.
Thank you, Judge. May I be excused?
You may be. Cause number 59, the state of Hazel Williams. Ms. Rendon, good afternoon.
Good afternoon, how are you?
I'm good. Are you testifying?
I am.
We swear you in?
I was here when we were sworn in earlier.
All right, you may proceed.
Okay. Decedent died on April 16th, 2024. Decedent's date of death was less than 4 years ago. Decedent was a resident of this county at the time of death. Your Honor, if you could take judicial notice that you have the original last will and testament of decedent in your possession.
Yes, ma'am. So that.
Alrighty. I recognize that document to be the last will and testament of Hazel Williams, and to the best of my knowledge, she did not revoke her will. She was not divorced after the date of the will. There are no children born to or adopted by decedent after the date of the will. There's no state, government agency, or charitable organization named as a devotee in the will. There is a necessity for administration. The will names her son Leon Willis as the executor. He is qualified to serve as such and accept letters. The will self-proof, state non-taxable, and we request the appraisal be waived, Your Honor.
That's Mary. Thank you, ma'am. All right, cause number 61, the state of Donald E. Stanley. That'd be Constable Stanley.
Morning, Your Honor.
Morning, you may proceed, Constable.
My name's Daniel D. Williams, attorney at law. I'm here to probate the will of Donald E. Stanley, who passed away on June the 28th, May 16th of 24 in Harris County, Texas. At the time of his death, he had a domicile and fixed place of residence in Anahuac, Chambers County, Texas. He left a self-proof will dated June the 28th of 2012. 4 years have not elapsed. He did not revoke the will prior to his passing. His will names his wife, Donna Stanley, to be the independent executrix of his estate. She's qualified, not disqualified from accepting letters. He was not divorced, nor was he married, and no children born to or adopted by him after the date of his will. No state or governmental agency or charitable organization was named in the will as a devotee. He did not receive Medicaid or Medicare after 2005. We asked, there's a necessity for the probate of the estate. We asked that it will be admitted to probate, Ms. Stanley be authorized and granted letters testamentary, and that appraisers be waived.
Done. Thank you, Counselor.
Thank you, sir.
Mr. Williams,
Yes, ma'am.
is this a muniment of title?
No, the Archie Delmont Dutton is the muniment of title.
Which is where we're going next. Cause number 64, state of Archie Delma. Now you may proceed on that.
Thank you, Your Honor. Take judicial notice. This was Johnny Dutton. Those Dutton boys never had a name that matched up. The decedent was a good guy.
Very good guy.
He died on July the 3rd of 2023. At the time of his death, he had a domicile and fixed place of residence in Baytown, Chambers County, Texas. 4 years have not elapsed since the date of his death. There is no necessity for the probate for the administration of the states. We asked the will be admitted as a muniment of title. He did not receive any Medicaid benefits, left a self-proved will dated March the 25th of 2010 that was not revoked, self-proved. No children were born to or adopted by him after the will. He was not divorced, nor was he remarried. No state or governmental entity was named. No charitable organizations were named either. We've investigated the affairs of the decedent, and there were no unpaid debts, and we're looking for this to be admitted as a muniment of title.
Did you leave me any hand-carved decoys?
No, but that's what my fee is going to be.
I don't blame you. All right, hereby admit the will of probate as a muniment of title. Thank you,
Thank you, Your Honor. May I be excused?
You may be.
Thank you.
Yeah. All right, I think we're back to cause number 85, the interest of Joan E. Fitzgerald. Is Mr. Mahoney on now?
I don't know if that's him.
Right.
Yep.
Good afternoon, Your Honor. Matthew Neaton here from Mr. Mahoney's office. Mr. Mahoney is caught up in a criminal case right now.
Okay.
I've spoken with the Fitzgerald family, though, and am familiar with the case, and I'm ready to proceed on behalf of Mr. Mahoney as ad litem.
All right, Mr. Carlson, you may proceed.
Thank you, Your Honor. This is John Blake Fitzgerald. I think y'all know each other. So Mr. Fitzgerald, you are the son of Joan E. Fitzgerald, correct?
Yes.
And is it true that your mom was born on May 1st of 1942?
Yes.
So making her 84 years old? Or 82, sorry.
82, yeah.
Yeah, sorry. And she currently resides in Chambers County, is that correct?
Yes.
All right. So we're asking the court today to appoint you as the guardian of the person, is that correct?
Yes.
And you already hold a financial and medical powers of attorney for your mother.
Yes.
Other than yourself, the only other family member that we've served in this matter is your mom's sister, Shirley Chambers. Is that correct?
Yes.
And does Ms. Chambers have any objection to you being guardian?
No.
The reason we're asking for the guardianship, even though she has powers of attorney, is that your mom's in pretty significant cognitive decline, as shown by the doctor's letter on file. And you're concerned that that there might be people out there that might want to take advantage of her, either personally or financially.
Absolutely.
Okay. And you're asking the court to appoint you as the guardian in order to protect her from something like that.
Yes.
Okay. And you are also handling her finances through the power of attorney.
Everything.
Okay.
Yeah.
All right. So other than her home and her car, pretty much everything is in a trust that your father set up.
Correct.
Your Honor, would you ask the court to take judicial notice of the doctor's affidavit and certificate on file with the application?
Okay.
Do you know, Mr. Fitzgerald, of any reason that you would be disqualified from serving as guardian for your mother?
No.
Okay. Have you ever been convicted of a felony?
No.
Have you ever filed for bankruptcy?
No.
And do you feel you're a proper person to manage her person and her financial affairs?
Yes.
Is there any guardianship pending for your mother in Texas or any other state?
No.
I believe that's all I have, Your Honor.
All right, Mr. Newton.
Thank you, Your Honor. And Mr. Fitzgerald, when you and I spoke previously, there were a couple of instances where somebody had already tried to take advantage of your mom's mental condition with regards to some money and some property. Is that correct?
Yes.
Okay. And so we're just trying to make sure that nothing happens to her and that she's kept safe from any that would have ill intent, correct?
Yes.
And according to the doctors, your mom's not getting any better. She's just continuing to decline cognitively, correct?
Correct.
And there's no hope for recovery, correct?
No.
I pass the witness, Your Honor.
Yes, sir.
That's all we have, Your Honor.
Okay, so do you, what about a bond amount?
Since she doesn't really have any assets outside of her car and the personal property in her home and her home itself, everything else is in the trust. So we would ask for a minimal cash bond if the court would entertain that.
Mr.
And
Newton,
Your
you
Honor,
agree with
after
that?
speaking with the family, we're in agreement with either no or low bond in this matter.
All right, I am going to approve a $50 cash bond. What about the ad litem fee? You agreed to the fee?
I have not received anything on my end.
I don't believe we filed, Your Honor. We would just be requesting a $600 kind of standard ad litem fee.
That's standard. Okay, so I am going to approve the $600 ad litem fee with $50 bond and appoint the permanent guardian of the person. Good luck, sir.
And just
Thank you,
for
Judge.
quick
Sir.
clarification, Your Honor, do
Go
we,
ahead.
I send a check for the cash bond or can I do that through the e-file?
I had to ask the clerk for that.
Well, I can call her afterwards.
She's right there.
A
Go ahead.
check, definitely a check.
Definitely a check.
Yes,
Okay,
it goes into a whole separate account, so please. And
But
call me
I-
if you have any questions on where to send it.
perfect. Thank
All
you.
right, thank you, ma'am. Y'all take care.
Appreciate it.
Thank you, Judge.
Thank you. All right, last but not least, cause number 47, the state of Atlanta, D. Montgomery. Ms. Renton, you're the only one left on, so
Hello again.
you may proceed.
Lena D. Montgomery died on April 30th, 2024 at the age of 81 years. Decedent's date of death was less than 4 years ago. Decedent was a resident of Chambers County at her time of death. I recognize the document dated October 28th, 2011 to be the last will and testament of Ms. Montgomery. To the best of my knowledge, she did not revoke her will. No children were born to by decedent after decedent's execution of the will. Decedent was not married at the time of death. Decedent was not divorced after the date of the will. There are no debts owed by a decedent. The estate consists of just a piece of real estate, so there's not a necessity for administration. Decedent did not apply for or receive any Medicaid benefits after March of 2005. There's no state, government agency, or charitable organization named as a devotee in the will. We're only asking this to be admitted to probate as a muniment and that the affidavit of fulfillment of terms be waived, Your Honor.
So done. Thank you, ma'am.
Thank you. Y'all have a good day.
You too. Take care.
Bye.